So the time has now run out for the DOJ to give their answer on what they plan to do with the nationwide vacatur and block of the ATF's pistol brace / SBR rule. So let's break down what is happening. As I mentioned in the intro, in this video, I have some news for you in the battle against the ATF and their current restrictions on brace pistols and treating them all as SBRs. Currently, there is a nationwide vacatur on the pistol brace rule and multiple preliminary injunctions which are protecting various toy organizations, companies, members, and customers. The Trump administration was set to have to respond to the Fifth Circuit on what they plan to do in a critical case called Mock versus Garland. This is a case that is in front of the Fifth Circuit Court of Appeals, and it was a result of a lower court issuing a final merits decision striking down the brace rule in its entirety. That ruling by the lower court is what's resulted in the nationwide vacatur of the rule and is allowing everybody to legally have pistol braces. The Trump administration notified the Fifth Circuit that they wanted to hold pending review of the case and hold any hearing on the case until the new administration could determine what they wanted to do in this lawsuit. Now, what ended up happening is the Fifth Circuit granted them a 30-day abeyance of the case, and it was set to automatically dissolve on Monday, April 14th. And so the DOJ and the AG's office said that they would essentially take that time, find what they wanted to do, and then give a status update to the Fifth Circuit. However, that timeline has now come and gone, and it's been much longer than April 14th, and we have no notice from the AG's office. At the same time, what we saw last week is that the DOJ and the AG's office then also decided to drop some criminal charges against an individual who was charged with illegally possessing an SBR because he had a brace attached to a CZ Scorpion. And in that case, he was charged with criminally having an SBR in violation of the NFA, but the AG's office dropped that charge. It appears a lot is shifting in regards to the DOJ and the AG's office and ultimately the ATF's policies when it comes to brace pistols. However, in this Fifth Circuit case, they've allowed that mandatory abeyance to terminate. It dissolved automatically, but we haven't got any notice from the AG's office on what they plan to do in the lawsuit. What we also saw recently is the DOJ let a timeline slip or just essentially dissolve in the Range versus Garland case, which was pending in front of the Supreme Court. So one of the things that the AG's office might be doing is simply letting these cases run their course, not meeting the deadlines or filing any responses, and essentially letting those cases die and letting those lower court decisions stand as they are. Now that would be huge for this case because remember, the lower court decision was a nationwide vacatur of the pistol brace rule nationwide in its entirety. And if that is allowed to stand, that means essentially there is no more pistol brace rule. Now, you may recall that the ATF suffered multiple losses in this case. There was a variety of pistol brace cases as well. Some got preliminary injunctions. And then also you had the final merits decision in this case. In this case, Judge O'Connor issued a final merits decision, and ultimately he struck down the rule nationwide on the final merits. In his decision, Judge O'Connor stated that at the conclusion of the majority's careful analysis, they held that the final rule is properly characterized as a legislative rule, and it is relatively straightforward that the final rule was not a logical outgrowth from the proposed rule. Therefore, the final rule must be set aside as unlawful or otherwise remanded for appropriate remediation. That decision was huge because, again, it struck down the rule entirely. In response to that, there was then the ATF appeal to the Fifth Circuit, and currently this is pending in front of the Fifth Circuit. Almost all the briefs have been submitted by the prior Biden administration who were fighting this, but now the Trump administration has control of this, and like I mentioned, they tried to put a 30-day abeyance on the lawsuit so they can determine what they wanted to do in this challenge. Through that notice, the Trump administration identified that it's likely going to change its position on pistol braces and the position taken by the prior administration in this specific lawsuit. Well, the Fifth Circuit responded again by granting that request to hold the brace case in abeyance for 30 days, but that clock has now run out, and it's been over a week now, and we got no news from the DOJ. That means that this case will proceed forward in one way or another, or the AG's office will take no action, and eventually the Fifth Circuit will rule against them and let the lower court's decision on the final merits striking down this brace rule nationwide, they will let that stand. One good sign for this case is the fact that recently the DOJ decided to drop charges against an individual who was charged with illegally possessing an SBR. Now, in that recent motion that the DOJ stated in a separate lawsuit, they stated that the United States, by and through this attorney, the United States Attorney for the District of Columbia, respectfully moves to dismiss count 1 of the superseding indictment without prejudice. The government is moving to dismiss count 1 in the interest of justice. So that was a good sign coming out of the DOJ that they decided to drop the short-barreled rifle charge against an individual for possessing a CZ Scorpion with a brace attached to it. He was charged criminally. That was in the US versus Taranto case. And recently we received multiple statements from the AG's office through the chief of staff that they will be changing position in this case and potentially other cases like the US versus Peterson case, which deals with suppressors. And that one's also in front of the Fifth Circuit, but that one's in the en banc panel. Her office has even now stated that they're going to be investigating localities in states like California for their delays when it comes to CCW permits. Those are all good signs, but of course, it doesn't mean that they're going to rule the way that we want here on pistol braces. But this inactivity is a pretty strong signal that they are not going to proceed forward in this lawsuit. We also saw recently that the AG's office established the Second Amendment Task Force, which is focused on two-way strategies and developing plans in cases like this one. I anticipate that if the AG is still not decided really what she wants to do, maybe she's going to ask for another extension, but it's been a week plus and we've seen nothing actually develop on the docket as far as them asking for additional time. They could try to stall this out and kind of deploy a stall tactic by saying, the task force is looking at this, we need more time. But as of right now, the automatic abeyance dissolving has already happened. And so we're waiting for some sort of update from the DOJ. And it might be that we get no update, similar to what happened in the Range versus Garland case, which was in front of the Supreme Court, where they just did not file according to the deadline. They did not file their cert petition. And because of that, they didn't meet the deadline and the lower court decision will stand. Now, one thing to note is even with the appeal happening in the Fifth Circuit, it hasn't impacted the nationwide vacatur of the rule that was issued by Judge O'Connor. That will remain in place until we get some sort of final resolution by the Fifth Circuit or the lower court. The lower court has already vacated it nationwide, but because the Fifth Circuit is still actively reviewing this and waiting on the DOJ, that will still remain in place. And it won't be until this case is remanded back down to the lower court, to the district court, Judge O'Connor, when he would issue the final order, stamping that, yes, he has vacated nationwide, the Fifth Circuit has not taken any action, and then that would kind of become the law of the land and the pistol brace rule would be struck down. One thing that seems to be happening right now in the AG's office is maybe she's struggling a little bit to get a handle on all these lawsuits. And maybe one of the strategies is to just simply not proceed forward or not, challenge some of these cases, not, move them forward, simply just take very little action on these and let the lower court decisions, which are already pro tuae, let those stand instead of litigating them at a higher level. But there is also some other things going on where you do have some Biden administration holdovers who are issuing anti-gun arguments in circuit courts like the Fifth Circuit. We saw that in the US versus Morgan case, which deals with machine gun possession charges. The DOJ there, the Biden administration holdovers have continued along the lines of arguing anti-gun policies, but that is going to be corrected. We've seen a lot of these cases have course corrections because the AG's office and the task force is looking at these challenges. So it's been over a week since that abeyance has automatically dissolved in the mock case, and we haven't really gotten any notice from the DOJ. However, we've seen action in other challenges, other SBR cases, other pistol brace cases, and it seems to be the policy of the DOJ and the AG's office that they are not going to protect the pistol brace rule and they're not going to defend it at a higher level. Again, if they wanted to stall the case, they could try to get additional time from the Fifth Circuit, but we haven't seen that happen and it's been over a week. So I'm starting to get the feeling that they are simply just not going to continue this battle in the Fifth Circuit, and they're going to let Judge O'Connor's decision stand and let that nationwide vacatur of the rule stand, essentially eliminating the rule nationwide. I think you can also draw that conclusion based on the fact that if the AG's office and the DOJ is not going to enforce the rule in other cases and saying that the pistol brace rule does not apply in other cases dealing with braced pistols, I don't think that they're going to defend the rule in a lawsuit. So I think that's probably what's going on here. And I also think that, the fact that they have not asked for additional time in the Fifth Circuit, despite the abeyance automatically dissolving, that could mean that they're just simply not going to proceed forward at the Fifth Circuit level. But as we get more information, as it develops, I'll let you guys know. But one of the big takeaways from this is regardless, the nationwide vacatur remains in place. And it seems like that decision from Judge O'Connor is going to remain in place regardless. And maybe the DOJ is just not going to challenge it going forward. If you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.